All right, so Patrick, here I had a case this week, and here's pretty much what happened. I reviewed a trust from another state.
Okay.
It was just signed and notarized. You had a few of those? No witnesses?
All the time.
Okay. One of the problems with this was attorney had done a deed for a Florida property to this trust.
Without a Florida law license.
Without a Florida law license, but that really wasn't the main issue, I didn't think, because a trust has to be witnessed and notarized in the same formality as the deed.
Correct.
So there were no witnesses on the trust, just notarized.
Mm-hmm.
So what would you have done? I'll tell you what I did.
Okay, so it was an out-of-state trust.
Mm-hmm.
No witnesses, just...
Well, now they've moved to Florida, though. So
now they're Florida residents.
Mm-hmm.
So the trust, was that a valid execution of the trust under the laws?
Well, I didn't check, but let's assume it was.
So if it was, I'd just say you do a what I like to call a domestication of a foreign trust through restatement. I think it cures any potential error in execution. It allows you to keep the original title of the trust. So if they have all those brokerage and banking and pieces of real estate in that trust, the title stays the same. We can hollow out all the out-of-state language, plug in good Florida language to protect Florida homestead, and make any other statutory updates and do it in the most efficient way possible.
Okay, I did that. I did a restatement.
You got it right.
But I also, well, thank you. But I also, in addition to that, I did a corrective deed.
I would have too.
Yeah,
I think that's
witnesses.
the right answer.
Yeah.
I mean, I think anytime you do the restatement and it was prepared by an attorney not licensed for the practice of law in this state in an abundance of was that deed recorded, by the way?
Yes.
Then I think you had to. Yeah, I think you'd have a choice.
Yeah.
So.